Another school which we likewise will consider is the natural theory of law. Now, the natural theory of law is likewise another jurisprudential opinion as regards the embodiment of law itself. Now, the natural theory of law, unlike other theories that has been aforementioned, has a couple of jurists who expressed their opinion on the natural theory of law. And in essence, we can see the like of Zenos, we can see the like of Grotius, we can see the like of Thomas Aquinas. And in expressing their opinion on the natural theory of law, they said the natural theory of law or the natural law can be said to be that which is fair, just, and right. So we can actually establish that natural law developed from the principles of fairness, from the principles of justice, from the principle of equity. So, in essence, natural law is that law that is fair, that is just, and that is right. So, according to the writer in Abiola Sani, it says, if 10 men are put in the same room and each man asked in the language that he understands whether it is good to steal, majority will say no. So, judging from this perspective, what the natural law entail is that human possess an innate attribute. Human possess an inner man, or human possess an inner characteristics that has the ability to filter out what is right from what is wrong. In essence, law should be programmed on the dictates of what this inner man dictates to individuals. So, like I mentioned earlier on, natural law is that law that develops from the principle of justice, from the principle of fairness, from the principle of equality. And as a matter of fact, natural law presupposed the origin of human rights that we now have today, as natural law seeks to actually protect rights of human and the ability of human to reason. Now, natural law as a school of law, which has been given explicit elucidations by Grotius, the like of Thomas Aquinas, again, is that aspect of law that is fair, that is just, and is right. Natural law, once again, is that aspect of law that is fair, that is just, that is right. Once again, this theory of law proposes that every human has this inner trait, has this inner attribute that dictates to them or that spells out to them what is right, what is not, what is good, and what is bad. And that this innate attribute should dictate to human what law is supposed to be. So it is likewise important to note that the natural theory of law is not without its own criticisms. Likewise, the natural theory of law has certain criticism. And one of these criticisms is that unless the natural law is promulgated, it does not have the force of law and cannot be enforceable. So it obtains that a law that is enforceable is the law that has been put in place by the body that has been legally empowered to do so. In essence, positive law. However, natural law, on the other hand, is not promulgated, is not entrenched. Natural law is not codified. Hence, it would go through the process of utmost difficulty in its enforceability or in its enforcement process. So it is also very important to note that another criticism that has been levied against the natural law is the multiple conscience problem. In the fact that natural law dictates that there is an inner man that tells the individual what is right and what is not. However, it is very important to note that what appears to be right to an individual may not appear to be right to another individual. What is good to another individual may not appear good to another individual. In essence, there is the problem of multiple conscience in that there cannot be uniformity of thought as regards the existence of rightness or wrongness. So it is also very important to note that the dictates of natural law are usually seen subjectively. Natural law is seen subjectively and not on the objective angle, as it is based on the interpretation of different individuals. So like I said, what is fair to one might not be fair to another. And what is fair to another might not be fair to one. And these are some of the criticisms that has been levied against the natural theory of law.